the law of the land until the question of the validity is determined by the new constituent convention. So a direct question which arose from this judgment of this honorable court in Yusuf Patel's case was sent to the court and it was answered. This is just...
So the question was sent here? Where does it say?
My lord, this is the... If you
originally referred were.
Yes, my lord.
And then what happened later? They said...
This is the judgment, my lord, where that question is then answered and the Supreme Court then...
Where is the question?
The question is, my lord,
questions originally referred were
page
suggested at
449, if your lordship may see.
These are the two.
Question number 2. If your lordship will see, just before the indentation.
Yes, so there were 4 questions.
Originally referred were 1 and 2, subsequently 3 and 4 were also suggested, but your lordship will find a direct reference to an earlier judgment of the court in question number 2.
Did they say they can do so? Where?
Yes, my lord. That is the entire thrust of this long opinion, and they say they can do that.
Under 186, whatever. What was the equivalent of 186 there?
Yes. And the question is answered. And the same has happened.
So, can we see the equivalent provision? Now,
Yes,
can we go
yes,
to your chart?
yes,
Should we go to your
yes.
chart?
My lord, the equivalent provision is there in the chart as Article 213 of the Government of India Act 1935.
Is it parameteria the same?
My lord, in a way it is not exactly the same language. If at any time it appears to the Governor General that a question, this is the last column,
Yes.
that a question of law has arisen or is likely to arise which is of such a nature and of such public importance that it is expedient to obtain the opinion of the federal court upon it, he may in his discretion refer the question to that court for consideration, and the court may, after such hearing as they think fit, report to the Governor General thereon.
Makhdum, is the question that was Yusuf Patel correctly decided or collaterally addressing Yusuf Patel?
My lord, if Yusuf Patel was correctly decided, then the government of the day was...
No, but the question is not whether Yusuf Patel is correctly decided.
No. And the question over there, my lord, is that in view of Yusuf Patel's judgment, if it is strictly followed, what is to be done? And the court then provides a way out.
Which does not upset Yusuf Patel.
My lord, Yusuf Patel remains as the law, but if your lordship sees the reasoning, in spite of the fact that all those laws which have been struck down by Yusuf Patel are allowed to remain in operation, which were essential till such time that a new constituent assembly comes in and provides a legal framework for the country.
लेकिन ना इसमें तो ये हुआ कि वो कहा कि यूसुफ पटेल the interpretation is correct.
Yes.
After that, how the government can run?
My lord?
How
Yes.
the government will run?
My lord,
उसको तो benchmark बनाया ना कि that is the interpretation by the final interpretation by the court.
correct.
After that, so that is an opinion sought by
The court that in view of the decision in Yusuf Patel's...
What was the decision that explained, Karlin? Because Yusuf Patel is not under question.
No, Yusuf, neither
That
is...
is one big distinction is
Ji.
this.
The consequences of Yusuf Patel were.
Because, my lord, if Yusuf
way out
Patel...
was sought from.
If Yusuf Patel was good law, if Yusuf Patel was fully given effect to by all the executive authorities of the country as they are required to, then the problem would be that the government of the day could not function. And therefore, they were virtually indirectly seeking from the Supreme Court a way out to continue to function in spite of Yusuf Patel.
And in Yusuf Patel, there was a review filed or not? Or what was the...
My lord, I am not aware, but it shows that whatever was the
So was
situation...
Yusuf Patel's case passed in review or was it just appeal? Or
Yusuf Patel was it's a criminal appeal and that's the final decision. And if there was a review, it's not on the record, at least as reported in PLD.
Interesting thing, same 5-member bench.
Yes. Yes.
So it wasn't even a larger bench, it was the same bench. Actually, we are a larger bench.
Yes.
So-
And my lord, before your lordship, to my mind, the question, the shorter question, the question of constitutional law is that if later or subsequent events disclose to your lordship that the judgment may have been infected or there was a reasonable apprehension of bias or reasonable suspicion of bias, can that judgment continue to be declared as good law?
So the question actually really could be, I don't know if that's possible, the question of law could not be going into the merits of the case, but the process through which that decision was arrived at. So at best, the question of law could be that this decision that took place, whether the process was correct or not. Yahi ho sakta hai na?
My Lord, that is my respectful submission. My submission is that when your Lordship approaches a judgment in your review jurisdiction, the question is whether it is in substance correct. When your Lordship is hearing a jurisdiction of advisory opinion under Article 186 of the Constitution, as your Lordship presently is, your Lordship is not concerned with the substance of the judgment. The question is whether the process by which it was achieved is something...
Which could also be a ground in review. Bias could be a ground in review.
But my Lord, if it was not apparent at that time, if it was not apparent, it was not known. And my Lord, your Lordship will see in this century, the closest example would that be of Pinochet number 2. Because there, and your Lordship will find, I'll take your Lordship through those passages, when a differently constituted committee of the House of Lords, as it then was, looked at it, they were pains to point out, each member of the House of Lords repeatedly, one thing is clear, Lord Hoffman was not biased. They repeatedly say he was not biased. But
Pinochet comes up through a review, is it, or through a...
No, my Lord, the UK House of Lords and UK Supreme Court, unless there has been a recent change, does not have a review jurisdiction.
So how did the matter look?
A submission was made. Submission was not contested. Submission was approved by the House of Lords that if a judgment suffers from a real likelihood or reasonable apprehension of bias, the House will always have the jurisdiction to reopen it and re-examine.
So this was decided earlier as an appeal, it was decided and reopened later?
My Lord, what happened was that the very, very brief facts of the case are that extradition of Mr. Pinochet was being sought. The Secretary granted the warrant. The Divisional Court at that time was decided the matter. The appeal came to the House of Lords. I'm just very briefly recapitulating the facts. In the appeal before the House of Lords, Amnesty International made an application.
This is the regular appeal.
And his Lordship's wife was a member of Amnesty.
Yes, two
that
facts.
Was the thing.
But this question was raised during the appeal.
No, my Lord, no.
That's what I'm asking.
Before the appeal, when leave was granted, Lord Hoffman was not a member of the bench. Then an Amnesty International application is moved. Again, Lord Hoffman is not a member of the bench to be joined as an intervener. When the appeal is heard, Lord Hoffman is a member of the bench. The bench, interestingly, my Lord, splits 3-2, like it split in this case 4-3, one vote difference. 3-2 the bench splits, and the bench holds that the extradition should be granted, decides against Mr. Pinochet.
Hoffman is the majority.
Hoffman is the majority. What happens thereafter is interesting, which my Lord, the Chief Justice pointed out. The parties make an application. Pinochet, on behalf it is made, that Lord Hoffman's wife worked for Amnesty International.
When was the application moved?
My Lord,
This was after the decision had been given.
Oh yes, my Lord. After the decision,
How late?
my Lord, after the decision is given, then the issue goes back to the Home Secretary to issue a warrant of his extradition. Before the Home Secretary, a letter is placed on the record. The letter states, and initially the letters were anonymous, given the fact that members of the House of Lords were involved, said that Lord Hoffman's wife worked with Amnesty International. In response to which the information provided was that yes, she did, but she was employed only in an administrative capacity, not involved with the decision making of,
ठीक है तो फिर वो
and that she performed certain secretarial duties.
And they took up this application.
This application is moved to the House of Lords. While it is still pending consideration, a further letter emerges. This letter now provides, it emerges from Chile, and it provides this is not enough. Lord Hoffman himself is a director and also chairman of another charity called Amnesty International Charities Limited. That is a charity which is controlled by Amnesty International. It has no role in the filing of the intervener application. It was not involved in that participatory process, but Lord Hoffman was there. And he is, of course, as a member of the superior judiciary, he could not act if it was any remunerative capacity. He was employed in non-remunerative capacity. So financial interest going back to times
no,
was...
तो खत्म हो गया.
Ji.
Then was the bench reconstituted?
Yeah, how was
or-
the application taken up?
The application was taken up by a completely reconstituted bench.
Under what jurisdiction under the UK law?
My Lord, at that time, the Lord Chancellor constituted the bench. The submissions record that the counsel for Pinochet submitted that you have always the jurisdiction to look at a judgment if it is infected with bias. And this
Only
is,
that portion can you read?
read that, yeah.
Yes. Only this very portion.
yes, जो नए volumes.
Which volume 1?
My Lord, no, this is a new volume. I just placed before your Lordship. This is tab 12 of this volume.
And this jurisdiction is under, what's the law that regulating the appeals and all?
My Lord, appeal is over.
No, but what is the law? I mean, they file their appeals under what law?
Common law principle.
Common law.
Common law principle. This application is moved.
Where is this portion
My
attended
Lord,
to?
if your Lordship may turn to tab 12.
Tab.
Page?
My Lord, tab 12, it opens at page 119. This is 2001 appeal cases, 119. Your Lordship may see first the petition itself is mentioned at page 121.
No, we just want to see the reasoning.
My Lord, if your Lordship turns to, and then just point, okay, I will just move away from the application and take your Lordship.
Sorry to
No,
nudge you along, but we
Not at all,
we
my
are
lord.
constrained for time also.
Your Lordship will see page 125. That is the first judgment, opinion authored by Lord Brown Wilkinson. There is introduction. If your Lordship will see 126G, is it highlighted? The relevant portion is highlighted for your Lordships.
Page?
126G.
Before your Lordship will see
Anyway, I
sideline.
just want to come to the reasoning part.
My Lord, this shows that they were made an intervener.
Yeah, that's okay.
Then your Lordship will see 127, the decision and afterwards. And the link is then pointed out, 127, if your Lordship may.
No, I just want to see
opening
the
up.
mechanism, how they overcame their earlier decision. That's what I was wanted to focus on.
And also perhaps how did they go about opening the matter?
My Lord,
I think their judgment is based on apparent bias. If you will see that page 132.
yes, my Lord. Yes, my Lord. But if
This
your
is the
Lordship
only
may.
reason which I have seen that only the question of bias was raised there.
Yes. And that is the issue raised over here.
No, fair enough. The question is, how did they open it?
My Lord,
They say,
if your Lordship will see the decision and afterwards on page 127. And your Lordship was asking for timelines. The timelines are also here. Judgment in your Lordship's house, the heading is decision and afterwards, was given on 25th November. The appeal was allowed by a majority of 3 to 2 and your Lordship's
No,
house.
we've understood that.
My Lord.
Now attend to the application and setting aside of the order of 3-2.
My Lord. For that,
How did they open the door and how did they?
yeah, the opening of the door first, please. I mean, how did they open the door?
all right, my Lord, if your
Oh,
Lordship.
they did not even mention it.
No, No, that of course mention it. They point out that this is,
Why don't you come to page 132?
My lord.
It's the conclusion which talks about the jurisdiction. I think that's dealt with the issue which is being...
apparent bias is there.
And please read the jurisdiction part,
My lord, I will.
page 132.
If your lordship may, before that, just graciously see the reasoning of the court begins at page 125. Your lordship was asking where is the reasoning of the court. 15 January 99, Lord Brown Wilkinson.
No, it says,
That's the first.
as my lord has pointed
If
out.
your
it
lordship
says-
turns to jurisdiction,
Yes.
that is page 132.
Let's read it.
As I have said, the respondents to the petition do not dispute that your lordships have jurisdiction in appropriate cases to rescind or vary an earlier order of this House. In my judgment, that concession was rightly made both in principle and on authority.
Where is the authority?
My lord,
Where is
that-
the
that
discussion on
follows.
this?
In principle, it must be that your lordships, as the ultimate court of appeal, have power to correct any injustice caused by an earlier order of this House.
So the principle of injustice.
Injustice.
No, so where in common law is this principle?
My lord, as follows, there is no relevant statutory limitation of the jurisdiction of the House in this regard, and therefore its inherent jurisdiction remains unfettered. In Broome Castle, your lordships varied an order for costs already made to the House in circumstances where the parties had not had a fair opportunity to address argument on the point.
Not the
Another
common law.
common law.
It's lovely.
That's the magic of the common law, my lord. It develops with time, with judges, as your lordship's approach evolves. Your lordship will see this.
Azuli Khan, one thing when you're addressing, I want to be very clear on this concept as well, because we have a review jurisdiction.
My lord, yes.
Our law is fairly settled about no second reviews. So where will we draw these lines if we are exercising such a jurisdiction?
I mean, enter
You
the
have to
Constitution
you have
to
to bear that in mind at each juncture.
My lord, there.
No, I'm just saying bear it in mind
Yes,
as
ma'am.
you're making
Yes,
your
ma'am.
submissions.
May I just preface it right over here, my lord, that generally your lordships have always regarded that in two respects, a decision is always available for reconsideration. One is the case of fraud, but that is now taken care of.
12(2), yeah.
12(2) by the statute. But the second is the case of bias. If a party is condemned unheard, or if the judge appears to suffer from a reasonable suspicion of bias, the test is as low as that, a reasonable suspicion of bias, then that can be undone. And if your lordship will see immediately after what my lord...
इसमें ये जो लास्ट पैराग्राफ है कंक्लूजन जो ड्रॉ हुआ है jurisdiction का, that is page 132.
जी.
इसको भी जरा देख लीजिएगा ना, because they have clarified.
Sorry, you were reading, I think let's finish reading
Yes,
this
ma'am.
paragraph.
Brown versus Castle, your lordships varied an order for costs already made by the House in circumstances where the parties had not had a fair opportunity to address argument on the point. However, it should be made clear that the House will not reopen any appeal save in circumstances where through no fault of a party, he or she has been subjected to an unfair procedure. Where an order has been made by the House in a particular case, there can be no question of that decision being varied or rescinded by a later order made in the same case just because it is thought that the first order is wrong. So as your lordships noted earlier, there is no review
Paragraph which I was asking to you read.
Yes, my lord.
This is
yes.
the same
Yes.
paragraph.
So
But
the
if you-
three crucial words that emerge from this paragraph are injustice, fair opportunity, unfair procedure.
Procedure. And-
Am I correct or?
Absolutely, my lord. And if your lordship will see, it flows into the next paragraph, apparent bias. As I have said, Senator Pinochet does not allege that Lord Hoffman was in fact biased. The contention is that there was a reasonable danger or reasonable apprehension.
Well, I think that's immaterial, probably where they were just being nice. I don't know. Let's leave that aside. I'm more interested in the constitutional legal principle, whether he was biased or not biased.
My lord,
I mean, we can say the same thing here also. I mean,
Yes.
you can't look into the hearts of men.
my lord, one of the reasons
Yes.
why the superior courts all over the common law world have evolved the test, which has varied from real danger of bias to real likelihood of bias to reasonable suspicion of bias is that it is almost impossible to prove bias.
But here, is it a question of bias, or is it a question of admission?
My lord,
Bias is that I had something against the accused appellant. That would be biased. Admission is that knowingly I decided something wrongly and I admit to it. That, would it be bias or would it be an admission?
My lord,
is it a different genre?
the latter part would be an admission of bias, but when you
It's not bias. It is admission of wrongdoing. It is.
wrongdoing, and when
Where is the bias? I have no bias, but on your saying I did something which I shouldn't have done in law. So I'm not biased against the person, but you prevailed upon me to do something.
But initially, from the portions of the transcript which were available and from what was appeared on YouTube, it appeared to be that the judge was saying that in this particular case,
Pressure tha.
is pressure tha. But when you
Where is the bias? He didn't say I hated him or I didn't like him.
but where he says that
Unfair procedure.
if your lordship reads his book along with his two interviews, your lordship will see that he is very clearly saying that in the case of the High Court at least, the Chief Justice who
नहीं, वो अलग बात है. हम Supreme Court की बात कर रहे हैं ना. हाँ.
Supreme Court mein he says that at that time the judges were under certain pressure. He doesn't say that there was any particular pressure on him. He also mentions that the chief
But this is, I think, a slightly different category of case from bias.
Unfair procedure.
So, my lord,
उसमें आएगा ना भाई.
my lord, the
If देखें या तो I don't take pressure, or if it is pressure that I cannot resist, then I should disassociate myself from the bench.
correct.
I don't know.
My lord, it will fall in the category again of Pinochet. Previously the test was financial interest or interested in the outcome of the
No,
case.
but then we will come under injustice or unfair procedure, not bias.
My lord, reasonable if on reading the transcripts of those interviews,
But I think bias is something subjective. Unfair procedure can be categorized as something more objective. I think unfair procedure or acting under pressure of someone is on a higher pedestal as opposed to bias. Because bias, you may think I am biased, but another person may not think I'm biased.
Correct.
And only I know if I'm biased or not. If I do something which is objectively, I say, I decided this case, Mr. Makhloom Ali Khan, though there was no merit in his case, I decided in his favor. Okay, that is something I am doing wrong. So there is no question of bias for anybody else, but I'm either favoring you or not, or just I don't like you, I'm doing something, one of the two. So I would really put it in a different category and on a higher category.
my lord, it would, but then eventually they would all fall under the broader category which goes back.
No, but is this maybe because there's never been such a category? Maybe we need to create such a category. I don't know.
My lord, the category is created in Pinochet from the point that where they take the view that if he had
There, the simple question was, because his wife, because of being a member, he may have been persuaded to canvass or articulate the viewpoint of Amnesty International. That may or may not be true. We don't know. Only Justice Hoffman and his wife would know that. Or the subconscious may have prevailed upon it. Let's even go that far. But nobody is saying that intentionally knowing that this order he should not have passed, he did pass. If tomorrow Justice Hoffman came out and said, I was under a lot of pressure from my wife, that whatever, if you don't decide this way, please find yourself another place to put your head down at night. I don't know. Now that would be a different category of cases. But that would be an admission of wrongdoing then.
that would be a category of admitted bias by a judge who was presiding over the trial. Because, my lord, when a judge decides on the basis of any other factor except the evidence before him and the law applicable to the case. It is said, there are categories, it is said that the judge was decided in a manner which was not proper,
And if he does it knowingly,
yes,
not unknowingly, we may decide
No.
cases wrongly, okay? I don't know.
any consideration, any knowing consideration.
So there's an element of mental mens rea, as in the criminal law we say. It's not just your act, it's your mind. You are yourself later saying it.
Mr. Makhdoom, there are a couple of questions.
My lord, yes.
Number one, I'm still at the opening of the door thing.
Yes, my lord.
And 186. So your proposition is that once an appeal is decided, review is decided, through 186, a question of law could possibly be regarding a decision that the process adopted in arriving at that decision was flawed, was unjust. Now, we would probably require you to tell us what would be that injustice, categories of that injustice. One is bias, as you just mentioned, and what else? Now, my second question would be, first of all, I'd like to know the list of all those injustices that could creep in as a process that would affect the judgment, one. And number two, would that not then entail an inquiry by this court to determine that injustice? Are we in a position under 186 to inquire, because that might entail recording of evidence, to come to that conclusion that there was injustice in the process of arriving at that decision? And I don't know, I think there are decisions which say that 186 does not entail, because we just have to answer a question of law. We're not going to get into evidence and inquire and figure out whether at all, if it requires evidence. So these are the two questions. First of all, what are the injustices that you think would affect the process? And then if that requires recording of evidence, how do we go about it?
My lord, the known categories are such, and I am restricting myself to cases even internationally where a final decision was made by a court of final appeal and thereafter a remedy has been provided. Not in a review jurisdiction, but in a subsequent jurisdiction. In subsequent issues raised, either like they were raised in the House of Lords through a common law application. Surprisingly enough, even in the United States, which is otherwise a country of statute law and the Constitution, such a remedy has come in through, again, the common law jurisdiction of the writ of coram nobis, correcting the errors which existed.
But if you could just list, it's very important to understand that if at all this argument goes through, that we're going to look at a judgment that stands settled by this court through the process being, what are those grounds?
My lord, the process goes back to the old principles of natural justice.
So,
Audi alteram partem and
okay.
nemo
No, I think
judex
it's
because sua.
because it was not a question of not being heard. I think let's as far as these cases, there may be cases where inquiry may be required. Is this one of those cases? If one of the judges says something, either you say he is not saying this thing, that's a different thing. And it was reported widely, recorded everywhere, and he could have said, I've been misquoted, I've been whatever, that he didn't do. He was a retired judge, so he could come on TV and say whatever he wanted to say. So that aspect, maybe there are cases which require inquiry, but probably this may not be one of those.
My lord,
so I'm back to really question of reopening the issue on rendering an opinion to the president, whether, and as far as the effect is concerned, I think effect, suppose it was a unanimous decision, suppose. And even if you take out one judge, it won't make any difference to the judgment. But here, it hangs by a thread of one vote. So it would make a material difference if they all were quitting for whatever wrong reason or right reason, or they were all convicted, or even if you remove one, it won't make any difference to the judgment. But here, it will have a practical significance on the judgment, and we're left with what the learned judge had subsequently stated that how he acted. So there may well be other cases where you cannot do it because you would require an inquiry. Do we require an inquiry? In this case, is a question for you to address.
My lord, my humble submission.
I will add to the question. I will add. Suppose if we believe that there was a bias, what was the question of public importance for the government to ask the court to give answer? Number one. Number two, whether since this judgment has been implemented, whether this question cannot be looked into in some other case, some regular case during appeal, in any other case. So what is the public importance matter in it?
My lord, the second question first. Insofar as the judgment is concerned, whether your lordships can look at it in appeal, obviously your lordships can, and your lordships can overrule it. It happens all the time. Your lordships have very recently done it in a case of which the reasons came out yesterday. But that's a different issue. The question is whether it's a question of public importance. There I would say that, my lord, once the president has framed the question and sent it to your lordships, the public importance aspect is decided by the president. But coming back to the question of my lord the Chief Justice, my lord,
And just, if I may just add one more thing to it, before you may also incorporate that. Can we ignore the elephant in the room? Martial law. I mean, can we really ignore that? I mean, can we not take that into, can we not factor into that? I mean, I would, a trial where the violator of the Constitution had a vested interest in the matter, the prosecution, he becomes a prosecutor before a court of law under martial law. It cannot be categorized as a normal court under normal circumstances, at least. So can we just completely overlook this and go into the finer aspect of the matter, or this would be a crucial factor to consider?
My lord.
And had they taken oath under PCO at that time?
Yes, my lord. Because what happened was PCO came in 1981, as your lordship will recall, 24th March 1981.
So
but an oath was immediately administered after 5th July 1977.
So even if it's not an oath, it's a physical violence part of it.
And the oath is mentioned in the Begum Nusrat Bhutto judgment, particularly by my lord Mr. Kaisar Khan at that time. My lord, may I take it a step further? Your lordship says that if it was a judgment, let us assume it was
We
7.
question. We don't say we question.
My lord, yes. Well, as your lordships observe, that if it was 7-0, if it was 7-0, and it later on turned out that one of the judges' conduct suffered from a reasonable apprehension of bias, I would respectfully submit that even then it would be a case for your lordships to declare that it was an unsafe judgment. And why, my lord? Because your lordships' deliberations are not public. One does not know what happens after your lordships have heard arguments in a case and go back and deliberate. Who was how powerful in terms of persuading the others and what role he played? It would be difficult to determine that. So once reasonable apprehension of bias is established in
But you are entering into the realm of conjecture. I'm grounding myself on the realm of facts.
My lord, yes.
The fact is simple. Yes, you may, one person may be so persuasive that he changed everyone else's view, but that's conjecture. This I know as a fact that he said something. So, yes, you're completely right, but why go into conjecture when we have a fact? There may be other cases we may have to conjecture that way. That may well be. But do we need to do so in this case?
Not really, but I was responding to a hypothetical assumption. My lord, if your lordship looks at the High Court judgment, in the High Court judgment, it was 5-0, which was later on upheld by the Supreme Court. It was 5-0, written by...
I think let's stay clear of the High Court judgment. Let's stay with the Supreme Court, because that will open another realm altogether.
Your lordship will find...
Because we are looking at the judgment of the Supreme Court.
Your lordship will find, it's up to your lordships, but your lordship will find that there are far more categoric statements by the sitting judges of the High Court of that time and by judges of the Supreme Court, not only Mr. Justice Naseem Hassan Shah.
No, but then the other question will arise, then what were the judges of the Supreme Court doing?
My lord,
Was that also raised as a ground before the Supreme Court?
Could you, then
no,
you
my lord, it wasn't.
effectively are re-arguing the appeal.
an application was moved before the learned judge himself requiring Mr. Justice Maulvi Mushtaq Hussain to recuse himself.
Right.
And he did not recuse himself.
I think there's an added thing that the trial took place in the High Court.
In the High Court.
Ordinarily, it would have been held in the Sessions Court. Now, we need to, I think later they will address us on the point whether it was by consent or opposed, because that also has to be clarified.
My lord, much better people will clarify that to your lordship, but my cursory examination of the record suggests that the order was made even without a notice to the accused, transferring it from the session court to the High Court, constitution of a 5-member bench, and cancellation of the bail earlier granted to him.
So sorry again to nudge you, but can you just focus on this aspect? We have not lost sight of these are very valid questions, but we want more from you from this constitutional aspect.
My lord, constitutional aspect, the submission is that the tests which your lordship have evolved in the constitutional domain
So you have primarily referred to one judgment from our jurisdiction, the Governor General's reference.
My lord.
The other one is the Pinochet judgment.
Pinochet judgment.
If you can sort of give us more citations
My
on
lord,
this aspect.
If your lordship will see,
Has there ever been a case where a judge later confesses or admits that he did wrong? Is there such a case?
my lord, in the common law jurisdiction, I have not come across one.
Okay.
So this is a first case, and when confronted with the first, like your lordship noticed in Pinochet, the court created a new category. Prior thereto, the category was don't be a judge in your own cause, don't have a financial interest. To that was added a category that no other non-proprietary interest will also disqualify.
Justice should also be seen to be done.
And-
That principle.
And
Yes.
that is where your lordship will find, I'm very grateful to your lordship for that observation. In the first judgment of Lord Wilkinson Brown, he goes back to the case of R versus Sussex Justices ex parte McCarthy, and he says the test remains the same, that justice must not only be seen, must not be done, but also be seen to be done.
No, Mr. Makhdoom, now, so as I understand, one could say that, I mean, your argument is that this judgment is unsafe because of the bias, because of the pressure. That's one document or one submission would be the video and the recording of one of the judges. What about the minority judges? Were they hunted later on and somebody had to leave the country? Is
My
that
lord, Mr. Justice Ghulam Safdar Shah
how do we understand that now?
leave the
You see,
country.
this is the larger picture.
Yes, the larger picture, my lord.
Martial law, Judge Justice Wahiduddin. So there are a number of other factors which come
Could you
in.
tell us those other factors that were circling around at that time? when
May I take your lordship's, give your lordship the trouble of taking a look at some select portions which I've highlighted
Yes.
of the transcripts of the interviews of Mr. Justice Naseeruddin Shah and Mr. Justice.
This booklet?
Yes, my lord, the one which was handed over just now.
Ji.
If your lordship will see.
Who were the minority judges, by the way?
My lord, in the Supreme Court, the minority judges were Mr. Justice Muhammad Halim, Mr. Justice Ghulam Safdar Shah, and Mr. Justice Durab Patel.
Right. Any interviews on their part or any documentation?
My lord, not really.
No, Durab Patel, there is.
Durab Patel साहब there is. I
जो
haven't.
टेस्टामेंट उनकी क्या किताब
My
है?
lord, testament of a liberal में बात इतनी clearly नहीं आती है, लेकिन there is, and Mr. Salahuddin Ahmed informs me, and I also recall that, there is an interview done by PTV, which is not on the YouTube in its entirety, but is available in the PTV archives. That is a full interview of Mr. Justice Durab Patel.
There is also a book written by General क्या नाम है उसका?
Chishti?
Aslam Beg,
Yes.
who also said about this case, revealed some facts about this case.
My lord,
So what happened to these judges? The minority judges were there except Justice Safdar Shah left the
except
country?
Justice Safdar Shah, Mr. Justice Durab Patel refused to take oath under the PCO of 24th March 1981 and thereby ceased to be a judge of the Supreme Court.
And Halim?
Halim Saab took
He would have
oath
been
under...
the Chief Justice of Pakistan.
Yes, Mr. Justice Halim took oath and became the Chief Justice
Should
of
his
Pakistan.
photograph not adorn this court?
And Mr. My Lord, then the list will be too long.
Many of those who did not become Chief Justices because of constitutional
उसमें तो
abrogations or subversions.
उसमें भी कई आ जाएंगे.
ज़्यादा लंबी लिस्ट नहीं है, छोटी लिस्ट.
हाँ, उसमें वजीउद्दीन साहब भी आ जाएंगे because he would have become Chief Justice.
रशीद रिजवी साहब भी शायद आ जाए.
जी, अगर वो हाई कोर्ट से all the way लेकर आए तो बिल्कुल. Sir, this is, my lord, the volume just handed over today. If your lordship may see tab 6.
जी.
My lord, this is a book.
Which number do you want to?
My lord, tab 6.
6.
Tab 6. This is a book by a senior journalist, Mr. Suhail Vadait. जस्टिस मुनीर से जस्टिस इफ्तिखार तक अदलिया के उरूज जवाल की कहानी.
ये अगर
नहीं सर, ये उन्होंने इंटरव्यूज इसमें कलेक्ट किए हुए हैं. इसमें दिस इज नॉट हिज कमेंट्री.
Okay.
And one of the first interviews, I think, my lord, if your lordship takes a look at this tab 6, this is
which page on tab 6?
the very first page. Immediately your lordship will see the first page 91 at the top.
जी,
Chief
ये
Justice of
interview.
Pakistan, Justice Naseem Hassan Shah. It's his interview, and this is one of the first.
पढ़िए, ये इंटरव्यू एक तारीखी इंटरव्यू है.
जी सर.
इसमें पहली बार
जस्टिस नसीम हसन शाह ने भुट्टो की सुप्रीम कोर्ट में अपील पर अपनी राय जाहिर की, जिस पर कई कानून दानों ने इनसे इख्तिलाफ किया और फिर लंबी बहस चलती रही. उन्होंने इस इंटरव्यू में भुट्टो की फांसी पर अफसोस का इजहार भी किया और कहा कि भुट्टो ने एटमी प्रोग्राम की तैयारी में बहुत बहादुरी का सबूत दिया. गर्ज के इस तरह की बहुत सी हैरान कुन.
ये तो एक कमेंट है.
Yes, sir,
Actual interview
if your lordship may turn to the interview, that is from page 93 onwards. I will not read the entire interview.
Just tell us where the relevant portion.
96 to start with. Page 96.
जी.
सवाल, भुट्टो की फांसी के बारे में कुछ बताएं. इस बारे में लोग जानना चाहते हैं. डॉक्टर नसीम हसन शाह, वो मुकदमा तो पहले हाई कोर्ट में चला, वहां 5 जज साहिबान ने वो मुकदमा सुना. उस वक्त मुकदमे के हवाले से छोटे मोटे वाकयात भी होते रहे. भुट्टो साहब समझते थे कि शायद मुझे पूरी सहूलियात नहीं दी जा रही. जस्टिस मौलवी मुश्ताक जो उस वक्त चीफ जस्टिस थे, उनकी और भुट्टो साहब की आपस में थोड़ी बहुत नाराजगी थी और मुश्ताक साहब भुट्टो से खुश नहीं थे क्योंकि भुट्टो साहब ने 8 सीनियर जजेस को छोड़कर जस्टिस असलम रियाज हुसैन को चीफ जस्टिस बनाया था. इसलिए कुदरती तौर पर उनकी टेंशन थी. फिर लॉर्डशिप टर्न्स द पेज. सवाल, क्या पाकिस्तान की अदालती तारीख में कोई
Can we do something more direct?
My lord, then if your lordship turns the next page where 98, लेकिन जस्टिस मुश्ताक के भुट्टो से इख्तिलाफात क्या थे, क्या इस सूरत में उन्हें समाअत करनी चाहिए थी. फिर जस्टिस अनवारुल हक पर भी भुट्टो के इतराज़ थे. डॉक्टर नसीम
मगर ये आप इंटरव्यू कर रहे हैं नसीम हसन शाह से.
जी.
वो अपने मुतालिक बात बताए ना, दूसरों के तो छोड़ें ना.
दूसरों के बारे में वो कहते हैं अगर वो मुकदमे की समाअत ना करते तो
अपनी बारे में बताए ना.
And then again it's about मौलवी मुश्ताक.
नहीं, वो छोड़िए ना, अपने बारे में बताएं.
100.
उन्होंने कहा कि मैंने गलत फैसला किया.
इस इंटरव्यू में नॉट दैट.
फिर इसको छोड़िए,
इसको छोड़ देते हैं. जस्टिस असलम रियाज़'s इंटरव्यू इज ऑन द नेक्स्ट पेज, page 151. And again, I have highlighted the relevant portions.
Was he on the bench?
He was not on the bench. He was not put on the bench. He
So
says,
why are we reading this?
my lord, just to point out, he says some things about Maulvi Mushtaq Hussain and how benches were constituted. And why he was not on the bench, he says.
page 100 पे क्वेश्चन
54, page 154.
पेज 100 पे क्वेश्चन रिलेवेंट है, जिसमें वो सवाल जनरल ज़ियाउल्लाह के साथ आप कैसे ताल्लुकात थे.
जी सर.
ऑफ दिस इंटरव्यू.
जी, उसमें वो बिल्कुल कहते हैं कि उनको जनरल जिया निकालना भी चाहते थे पर उनको जस्टिस सलीम
उन्होंने
ने
कहा
बचा
कि ये
लिया.
मेरे कंट्रोल में है. आखिरी लाइन देखें. जस्टिस सलीम ने ज़ियाउल्लाह को यकीन दयानी करवाई कि ये मेरे कंट्रोल में रहेगा.
जी.
तो हलीम साहब तो एक्विटल जजेस में
जी जी एक्विटल जज थे।
लेकिन वो कंट्रोल में,
आई डोंट वांट टू इंट्रोड्यूस सेकेंडरी एविडेंस, प्राइमरी पे रहे ये।
लेकिन वो कंट्रोल में नहीं रहे हलीम साहब थे।
जी
नहीं, ये देखिए, ये साफी की ओपिनियन है और ये सेकेंडरी सोर्सेज हैं। प्राइमरी सोर्स हो गए जज ऑन द बेंच।
Aslam Riaz Hussain Sahab explains, I will not read it, on page 154 why he was not included in the bench. Then page 157.
नहीं, हम ये बातें
How the
छोड़,
benches were, your lordship was
साहब, इसके लिए
inquiring
हमने
about
आपको-
how benches were
अब ये
manipulated.
मेमोआज में आ जाए ना, जो ये खुद कह रहे हैं, इधर कोई चीजें तो
जी सर,
बताइए।
उस पे आ जाते हैं सर। That in the memoirs, if your lordship turns to the memoirs, your lordship will find that in tab 8.
जी, पेज 186।
Yes, my lord. Page 183 say appeal against conviction. I put in that entire sub-chapter over here. But if your lordship turns to page 186, and this is important, my lord, about the influence on constitution of benches. And this is direct what happened to Mr. Justice Naseem Hassan Shah himself.
ये तो बेंच की बात हो रही है।
Gee, but how he was included. Mr. Bhutto filed an appeal before the Supreme Court against the death sentence. At that time, I was still an ad hoc judge in the Supreme Court. The possibility of such an appeal coming up for hearing before me was remote. Such important matters were never placed for hearing before an ad hoc judge, and it was normally a bench of permanent judges of the Supreme Court which would hear them. This normal practice was not followed in this case. It was sometime in the beginning of April 78, while I was getting ready to attend an evening function. I was informed that Mr. Justice Mushtaq Hussain, Chief Justice of the Punjab High Court, and Mr. Sharifuddin Pirzada, Attorney General, had come to see me. I went to the guest lounge to meet them.
ये it's not relevant।
Yeah, this shows, my lord, your lordship's question was...
नहीं तो okay,
how-
fine, तो you can't force a judge to be on a bench. He could have recused himself।
that he was put on the bench.
No, but he's making it sound that he was under compulsion to be on the bench. He could have simply recused himself।
That's true, my lord. And page 199. Lordship, what was the
ये
effect?
वो जैसे इफ्तिखार जो अहमद साहब जो जर्नलिस्ट हैं उनका इंटरव्यू है ना,
वो भी पढ़ा
डायरेक्ट बात करें
जी,
ना।
उस पे आ जाते हैं। 199 सिर्फ देख लें।
हाँ?
199, page
हाँ,
199
जी,
in
जी,
the
I'm there.
same tab.
Yes।
No accused ever had more favorable judges, and but for retirement of one and sickness of the other, the panel was in his favor. Your lordship said how
The favor could be that, okay, I was in your favor, but there was so overwhelming proof I had to do this. So favor would be washed away then. Let's go direct to the interview of Mr. Iftikhar Ahmed. वो कहाँ है?
My lord, yes, that interview is also, I have filed that, my lord. That's before your lordship. This is tab 7.
मैडम के पास नहीं है ना,
जी।
If your lordship turns the page in this one to where it directly confronts the issue. This is page 8. The paging is at the foot of the
ये
page.
पढ़े ना, अब ये बात आई।
इफ्तिखार अहमद
जी।
आप जुल्फिकार अली भुट्टो केस में मौजूद थे। जस्टिस नसीम हसन शाह जी, इफ्तिखार अहमद, आपसे अगर पूछा गया जाए कि क्या पाकिस्तान की अदालती तारीख में कोई ऐसी मिसाल है कि महज मशवरे की बुनियाद पर किसी को फांसी दी गई है?
एक सेकंड। It is tab 7.
Tab 7,
page 8 of tab
The
7.
paging is at the foot of the page.
Tab 7 लाल वाला है। जी। लाल वाला।
पे क्लिप 4 लिखा हुआ है।
क्लिप नंबर 4 है।
Number 4, page number 8. आपसे अगर ये पूछा जाए कि क्या पाकिस्तान की अदालती तारीख में ऐसी कोई मिसाल है कि महज मशवरे की बुनियाद पर किसी को फांसी दी गई है? जस्टिस नसीम हसन शाह, जी हाँ, मेरे ख्याल में मशवरा तो नहीं था। इसमें तो वो था कि इनका ऑर्डर था कि वो यानी अपने सबॉर्डिनेट्स को कि उसको रजा कसूरी को ख़त्म कर दिया जाए, तो लिहाजा मशवरे की और बात होती है और ऑर्डर की बात और होती है। वन क्वेश्चन डाउन, माय लॉर्ड। मुल्क का वजीर आजम हूँ, आपके सामने पेश हुआ हूं, मैंने आपको प्रमोशन नहीं दी, आपको बिठा दिया गया है। मैं कहता हूं आप मुझसे इंसाफ की तवक्को नहीं है, तो आपको क्या करना चाहिए था? जस्टिस नसीमुद्दीन शाह, तो मेरा नहीं ख्याल कि किसी को उन्होंने कहा कि ऐसी बात की मुझे तवक्को नहीं, बल्कि उन्होंने तो हमेशा कहा कि मुझे सुप्रीम कोर्ट पर पूरी इफ्तिखार अहमद। मौलवी मुश्ताक की बात कर रहा हूँ, मौलवी मुश्ताक साहब को जुल्फ़िकार अली भुट्टो ने कहा जस्टिस नसीमुद्दीन शाह, जी हाँ, वो मेरे ख्याल में मौलवी साहब की ज्यादती थी, क्योंकि यानी वो बहुत ही जबरदस्त आदमी थे और वो भुट्टो के दुश्मन थे और उनको चाहिए था कि इस केस में ना बैठते तो बेहतर था।
वो उन्होंने जो कहा था ना, प्रेशर था मुझ पे फौज का, वो किधर है?
Sir, that is earlier on, that is in the general context as to what happened. That is not specific to this case. And I'll take your lordship to that, but if your lordship may just complete this, page 9. सर, आपने एक जगह पर अपनी राय का इजहार किया कि आपने कहा कि भुट्टो केस की समाअत के दौरान मेरी यानी आपकी जाती राय थी कि भुट्टो की सजा में कमी हो सकती है। जस्टिस नसीमुद्दीन शाह जी, इफ्तिखार अहमद, और इस सिलसिले में उनका केस बड़ा मजबूत था। जस्टिस नसीमुद्दीन शाह, हाँ बिल्कुल। इफ्तिखार अहमद, मैंने भुट्टो के वकील याया बख्तियार से पूछा कि क्या मौत की सजा में कमी के बारे में दलाइल देना चाहते हैं, तो उन्होंने इनकार कर दिया। जस्टिस नसीमुद्दीन शाह, ठीक, तो साहिब जज साहब, जब आप कन्विंस थे तो जब आप फैसला दे रहे थे तो डिसेंटिंग नोट नहीं आपको लिखना चाहिए था कि इस हद तक सजा ना दी जाए। जस्टिस नसीमुद्दीन शाह, जी हाँ, हो तो सकता था, मगर वो जो इनका वकील है वो कहता है मुझे सजा की कोई परवाह नहीं, मुझे तो एक्विटल चाहिए। मैं समझता हूँ भुट्टो यानी जो है इफ्तिखार अहमद, सर आप भी डिसेंटिंग नोट तो दे सकते थे ना। जस्टिस नसीमुद्दीन शाह, दे तो सकता था, मगर यानी मेरे ख्याल में उसमें कुछ थोड़ी सी हमारी भी कमजोरी है और कुछ उसकी याया बख्तियार की भी थी, यानी जिद, उसने हमें एक किस्म का नाराज कर दिया। इफ्तिखार अहमद, अच्छा, याया बख्तियार ने आपको नाराज कर दिया, लेकिन सर आप खुद तस्लीम करते हैं कि भुट्टो को ये मिलना चाहिए था, बेनिफिट ऑफ डाउट मिलना चाहिए था। जस्टिस नसीमुद्दीन शाह, जी हाँ, ये तो अगर आप इसको जाती तौर पर तस्लीम करते हैं जैसा आपने माना, अगर आप डिसेंटिंग नोट लिख देते तो आज पाकिस्तान की तारीख मुख्तलिफ ना होती। पता नहीं मुख्तलिफ होती या नहीं होती, मगर कम से कम उसकी जान बच जाती। So that's,
but this really putting the blame on counsel. I mean, if counsel doesn't argue properly or whatever, even if we accept that, there are two punishments. We are going into punishments.
Yes.
The person may not insist on it because he may think I've got such a ironclad case. Why should I seek for lesser punishment? That would involve, in a way, admission on my part that it's applicable. And very well the council may not take that thing, but it doesn't mean that the judge should not consider it. That's a different thing altogether. So as perfectly as tactical ploy, the council will say absolutely not. I'm not interested in lesser punishment. I want a clean acquittal. So why should that be held against counsel or the accused? I don't see the logic of this argument.
but my lord, the only explanation on the transcript of this interview, I am not aware whether otherwise there was one, is that he says कि उसने हमें एक किस्म का नाराज कर दिया था।
हाँ, वो बात आप कह सकते हैं
जी,
नाराज कर दिया तो या तो सुनना छोड़ दें या फिर भी इंसाफ करें।
and in his,
हम भी नाराज हो जाते हैं कभी, ये तो मतलब नहीं कि फैसला उलट दें, कभी कभी वकील की सजा उसको तो ना मिले ना मोकल को।
सब ये अपील में उन्होंने अल्टरनेटली मिटिगेशन के बारे में कहा है या नहीं कहा? ये तो ये कह रहे हैं ना कि हमारे सामने नहीं कहा। अपील में नॉर्मली एडवोकेट जो हैं वो एक अल्टरनेट रेमेडी लेते हैं, तो क्या वहां मिटिगेशन के बारे में कुछ कहा गया कि ये नहीं हो सकता?
sir, it appears from Mr. Justice Durab Patel's judgment in the review note that this was an argument made for the first time in the review petition.
नहीं, मेन माय लॉर्ड पूछ रहे हैं कि मेन जो जजमेंट था
अपील में क्या लिखा?
In the review it appears that they refused to look at it on the ground that this was not a submission made in the main appeal. So the review judgment suggests that this submission was not perhaps made in the main appeal.
सबमिशन करना समथिंग एल्स
जी
क्वेश्चन राइज जब भी अपील लिखी जाती है
जी सर।
तो उसमें एक अल्टरनेटली ये कहा जाता है कि इट्स नॉट एक्सेप्टेड केस फॉर कैपिटल पनिशमेंट उसके मिटिगेशन के सर्कमस्टांसेस बता दिए जाते हैं। मैं वो कहता कि अपील में कोई ऐसा है ये तो कहते हैं हमारे पास सबमिट नहीं किया वो तो कह रहे हैं लेकिन उसमें है या नहीं है बस ये क्वेश्चन।
Lord, insofar as I am aware, no.
Makhdum sahab, such like submission pleas are made in the submissions before the court. Alternate remedies asked from in the court.
Yes, yes.
उसमें लिख नहीं देते because सारा केस फिर उधर चला जाता है कि alternate remedy।
क्रिमिनल अपीलें आप देखें 4 लाइनें की तो लिखते हैं कुछ लिखते ही नहीं उसमें unlike civil pleadings but the fact remains that the judge has to consider it if a lawyer doesn't take this plea. Actually, we do the whole thing very lopsided in Pakistan because every criminal case has two components which we tend to overlook. One is conviction and one is sentence. I mean, in the West, you have a separate date of hearing of matters for sentencing. Then that person then pleads, these are the mitigating factors. Here we roll it all up into one. And this is the duty. I don't think it's a duty, even if the council doesn't take it, wherever it's the duty of the judge to see if mitigation is there. Because then you err on the side of caution and you give the lesser sentence as opposed to maximum one. And then you have to justify the maximum one because it was a horrendous crime or whatever you want to say. So that's the general way it should happen. Otherwise, criminal appeals don't say much. I mean, if you read criminal bail applications, they don't say anything.
Sir, I have never read it myself, but I have heard from senior members of the bar, some of them are no more, that one of the most celebrated criminal appeal lawyer before the Lahore High Court, West Pakistan High Court at that time was the late Mr. M. Salim, whose entire murder appeal used to consist of one sentence: the judgment of the trial court is opposed to the facts of the case and contrary to law. And M. Salim.
Yeah, we also see the same pattern still.
Because it's a first appeal and all the facts and the law have to be examined by the High Court, so there's no point in going through it, and that's how it was done. There was a printed form, I'm told, of the Lahore High Court, and he would add only one sentence.
Is this the only case where the High Court had heard a case of murder as a court of first instance?
My lord, in Pakistan,
is there any other precedent? I'm not aware.
There may have been other, but in reported judgments in Pakistan, I have not come across. But that may be on account
So
of
we just raise this question. Maybe some other council can also address it. Whether this was the one and only case of its kind which was heard by the High Court, because I'm more looking at the totality of the matter as opposed to individual things.
Yes, my lord.
Martial law, High Court trial, one right of appeal lost. You saw all these factors, 3-2 split decision. I don't know of any other, and is there any other case which has been, you've given capital punishment on a split decision? These are all these other factors which come into play. Then, as my lord observed, that some of the judges were persecuted.
And Justice Durab Patel, when your lordship summoned that transcript from PTV, says that in a split decision like this, it doesn't happen. He says that even in his review, very short.
Even if he doesn't say it, that's a general principle of law.
Even in the review judgment, my lord, which is a one-page judgment where he concurs with the majority, but he says that this is a point which has been highlighted, and from India a judgment has been produced where the split was 2-1.
But unfortunately, he was part of the review of a unanimous review.
Yes, my lord. But
that is what's troublesome also. All 7 were unanimous on the review.
My lord, but if your lordship reads the review judgment of review opinion of Mr. Justice Durab Patel, there's a very short opinion, about a page and a half.
I've read it.
Yes, my lord, it says very simply why he's there. He said Mr. Yahya Bakhtiar has argued.
He's put all the blame on the council.
No. He says 2 things, my lord. He also says that while arguing this case, he has been unable to persuade the majority to change its mind. So the outcome remains unaffected. And
the outcome to sentence doesn't remain unaffected. There can be the capital punishment, or there can be imprisonment for life.
On that, my lord,
I think the basically determining factor is it the duty of the judge or is it the duty of the council? In my opinion, it's the duty of the judge. to look at it.
On that, his view is, with which Mr. Justice Ghulam Safdar Shah and Mr. Justice Muhammad Halim agree, that this is raised for the first time in review, and he mentions that and he moves on. But his basic thrust of his reasoning appears to be that you have failed to persuade the majority, so if we just reiterate our views earlier expressed in dissent, where would that lead to? The judgment would stand.
I'll just tell you a simple thing. This is a criminal appeal.
Yes, ma'am.
What are you saying? Set aside the judgment. Basically, you're saying that in a criminal appeal. You're not saying, let the judgment hold, but give me a lesser sentence. I mean, you're not really saying that in a criminal appeal. That's only a matter of law, settled law, whether you will grant a lesser sentence or not. For the judges, with the greatest respect, to say that it was not argued before us, I don't think that is probably correct approach, because we always look to mitigation, whether it's, whenever I've heard of cases, whether it's argued or not.
My Lord, correct.
Unless it's a case where already the lesser sentence has been given. Then the burden shifts. Then the state or the complainant may come for enhancement of sentence. There the burden he has to plead. That I'm standing by the judgment, but please enhance it. There was no justification for giving the lesser sentence. That would be altogether a different category of case. For enhancement, this, you are here, if he set precedent, I don't know of any other court which has followed this precedent, that's for the counsel to plead lesser sentence if we uphold the judgment. Why should he do it?
Outside, as your lordship observed, it's different because the judge
Pakistan we're talking about.
but because over there, my lord, the judge of facts and
Like I told you there, that there are two separate hearings altogether.
yes, because the conviction is for the jury, and once the jury has convicted, then the sentencing is for the judge, and it's the sentencing stage that the plea of mitigation comes in. And simply because you have pleaded for acquittal doesn't mean that you cannot put in a plea for mitigation in sentencing. But because of the two stages, it is possible to separate that. Over here,
Going one step further, I think it's the duty of the judge to consider it in a capital offense. Not maybe in other offenses, but definitely in a capital offense.
my lord, if following that line of observation, the submission is,
I may be wrong, you can correct me.
my lord, the submission is that it is all now, all these requirements of natural justice and fair procedure get merged into one simple doctrine: the duty to act fairly. The duty to act fairly by the judges, and where their duty is in any manner affected, then it is said that the case can be reopened.
And the question,
Can you go back to the constitutional point and let's finish that?
My lord,
question was asked, Mr. Maktoum, question was asked by that person from Naseem Hassan Shah, कि क्या आप ये खुद नहीं कर सकते? तो उन्होंने कहा कि जी मुद्दई सुस्त गवाह कोई आया नहीं.
जी, जी,
So
बिल्कुल.
this is the duty of the judge to consider, to deliver justice.
वो भी उन्होंने कहा है वो थोड़े से नाराज हो गए थे.
ये अगर एक्सट्रैक्ट, अगर जनरल असलम बेग की बुक एक्सट्रैक्ट, आई थिंक इट इज रिलेवेंट, आपको मिल जाएगा. अगर ये पढ़ ले, दिस इज आल्सो आई थिंक रिलेवेंट इन दिस केस.
And Makhdoom Sahab, was he talking for himself ke naraz ho gaya tha, or he was talking for the other judges also ke sab naraz ho gaye the?
Your ladyship, it appears that he was talking about himself, but I have not read the entire chapter of that book which I have put in, authored by the learned judge himself. He says that there was a feeling originating from the Chief Justice that the bench is splitting along provincial or lines, and therefore the Chief Justice sent him as an emissary to Justice Durab Patel that if you agree, we can all agree to a lesser sentence. That is not at the review stage, my lord, that is at the appeal stage. And he says, longish discussion with Justice Durab Patel. He said, no, I will decide what I think. I have to decide according to my conscience. You do whatever you think. Right?
There will come another problem. ये भी जरा आप ज़हन में रखिए. A judge retires. He may well be pursuing a political career.
Sir.
आप ये बयान तो देते कि आपने गलत फैसला किया था.
By then he was probably 90 or more than that.
So we don't want to just go on these sort of flimsy matters of what a person says upon retirement. We want to be more grounded on facts. what were the facts? I mean, आप ज़्यादा बात नहीं कर रहे हैं martial law की.
My lord, if your lordship takes a look at the facts, I'm not mentioning those facts because those facts are now all part of our collective memory. Your lordship,
It's not part of a collective memory. They have to be reiterated.
Your lordships, in the first round, different bench sharing it, a number of books were handed over to the amici as well. There's the book by General Faiz Ali Chishti.
ये ये सब चीजें लिखा होगा, उस पे फैसले होने लगे तो सारे जजमेंट्स उड़ने लगेंगे.
नहीं,
किसी जज ने रिटायरमेंट पे आके ये कह दिया, वो कह
He
दिया.
was the right-hand man of General Ziaul Haq, and he says that Ziaul Haq had come to the conclusion that it has to be his neck or mine.
Yeah, so that's
he
the
doesn't
background. Have to say it.
That's the background. And your lordship will find that in Mr. Justice Aslam Riaz Hussein's interview, he mentions the same thing as well. That's already on the record before your lordship.
Can we go back to case law, President?
My lord, case law, Pinochet I have cited, and may I just briefly say what Pinochet stands for. Pinochet stands for that if the judge has an interest in the matter, that interest doesn't have to be pecuniary, that this interest doesn't have to be proprietary or personal, that interest is enough, because then the decision cannot be said to be solely based on the evidence on the record. So anything which affects the judicial mind besides the evidence on the record is something which will disqualify. Now, what is the test? The test is not what a 9-member bench of this honorable court thinks. The test is what the man on the street thinks. What is the common perception? Is the common perception that there was a reasonable apprehension of bias in this case? And if that common perception of reasonable apprehension of bias is vindicated by the surrounding circumstances, by journalistic writings, by writings in history, then that all gives a flavor of what was happening. My lord, bias may not be just martial law. To give your lordship an example.
No, but can we go on?
Yes, my lord. Moving on.
No, the other point would be, can we then open every case on this basis?
No. That's why I'm saying what happens.
Where is the distinction?
Your lordship will find no other case where a sitting member of the bench has cast doubts on its correctness on account of circumstances other than the evidence in the matter. Your lordship will find no other case where even decades later a sitting prime minister in 2023 stands up before the National Assembly and refers to this decision in the words, and that transcript I have put on the record as well, my lord. That is the speech made on 4/4/2023. That's
Can we not go that far as to say, you know, I am very disturbed by martial law. The minute you start accepting it, everything goes wrong. The minute you stop it, everything goes right. Why can't we stop at that? Why are we not addressing that at all? We're going Pinochet. There is martial law in the country. The judges have been weeded out, selected, chosen, whatever you want to say. A trial of a person, the martial law administrator has deposed. These are not insignificant factors.
Correct.
So why are they not being stressed enough?
My lord, they are, but may I stress them by reference to the case law. For instance, my lord, in US there has been no martial law as such. But the specter of war, where the military is supposed to know its best, has resulted in judgments which have later on been regretted, and in which the convictions awarded have been held to be unsafe, and in which compensation has been awarded.
Let's go there. I wanted to.
Yes, my lord.
Sir, we have to kind of, if you don't mind.
No, my lord, we move on to those.
Please don't mind it.
Not at all, my lord. We move on to those cases, and you will find.
Because Amicus spent time.
My lord, if your lordship will take a look at the volume 1, the blue volume.
G.
Your lordship will find in the index, there is an article by Lord Bingham who traces some of the history of some of this case law. I will not read it. I'll just identify. It is at page 116 to 130
of this particular
blue
case.
bundle. This blue bundle, my lord, volume 1. Page 116 to 130. In index, it is at number 16.
Lord Bingham was a judge.
And prior to that, if your lordship will see,
Ji? Which page are we referring to?
my lord, if your lordship takes a look at the index, page 2 of the index, your lordship will see item number
टैब
16.
कौन सा है टैब?
नहीं, 116 पे है.
सर इसमें टैब नहीं थे
नहीं, 116 पे lives of law.
जी सर, lives of the law, page 116 पे है.
There's no index. It says selected essays and speeches.
Index is right in the beginning of the volume, my lord.
Oh, no, but which page should we go to?
116. I'm just referring it to it. I will not read to your lordship. I have.
What do we read from here? What?
My lord, he points out cases from Liversidge versus Anderson in England to Korematsu and Hirbayashi in United States, where at times of war, the courts made decisions which were unsafe, and when the specter of war had receded, the courts offered correction. In the case of United States in particular, the error was made all the way up to the US Supreme Court, and the correction is made later by the federal court. Those are at 13 and 14.
No,
If
no,
you're
but
not-
the correction is made judicially through another judgment.
That is made at,
That's another jurisdiction altogether.
my lord, that's a common law jurisdiction again. They
No, another case comes and they correct the earlier principle.
No, in the same case. In the same case, awarding compensation to the same persons whose appeals had been turned down by the Supreme Court.
So it means every judgment passed during the martial law tenure can be looked into.
My lord, your lordships will have to
We
examine.
have already a bundle of cases, and if you indulge
Lord,
yourself in this scenario,
Your
then
lordship will find it very difficult to get another case where the circumstantial evidence, both contemporaneous and later on, points the finger that the duty to act fairly was not observed in this case. Your lordship will not find another case. This is singular.
this can be rectified by the parliament.
How will they
Other
do that?
parliament has endorsed all those acts of the martial law in the parliament.
My lord, he could
This is
have
for the parliament. Why they are not doing so?
he could have been pardoned by the president at that time. That was Ziaul Haq. Can he be pardoned now?
This is what has been discussed by
What is the answer to that question?
Well, what, my lord?
Post true, after death pardon.
My lord,
Have you considered it or not?
my lord, it is for the Attorney General to inform your lordship whether that was considered or not.
No, legally can it be done or no?
नहीं मखदूम साहब मेरा भी एक सवाल है supposing this case Mr. Bilawal Bhutto, this case is decided in their favor and this murder this is considered as a murder, can will the court allow Mr. Bilawal Bhutto and Zulfikar Ali Bhutto Jr. to ask for qisas?
Your ladyship, in other jurisdictions, and those are the two cases I would refer, the courts themselves have awarded compensation if they wanted to. But over here, it appears to be nobody's case that they are seeking any
I
compensation.
think here we have a very limited presidential reference.
Yes, my lord.
To render an opinion on, I mean, I don't even think we can set aside, we have to render an opinion whether it's good case law to follow. I think that was a question which was
Well-
primarily referred to.
And the first question, my lord,
what would be
takes
the remedy? I mean, what remedy they are going to get from this case if this is decided in their favor?
your ladyship, remedies are not always tangible. The only thing we carry to our graves is a reputation. And-
Already this case is not referred to in any criminal cases.
I may put it differently.
It's a bad
In the
judgment.
court of the people, in the court of history, this decision has been turned down in any event.
Yes.
It is now before a court of law that whether it squares up with Article 4 of the Constitution and the due process of law. So they are not seeking vindication in
Could
the
be
court
only
of
an
history or court of people.
We cannot substitute our finding with the trial court, appellate court, Supreme Court and the review jurisdiction.
My lord, no findings
This is
are...
only for the opinion purposes.
My lord, and your lordship's test over here is different. Is your lordship going to provide any relief to the accused in this case? No, he is beyond release.
It's beyond this.
What is over here, the pivotal question is the public confidence in the fair administration of justice, summed up in a series of judgment that was there a reasonable apprehension that justice was not seen to be done.
So could you just list all your points? Why was this judgment unsafe? 1, 2, 3.
My Lord, in my respectful submission, this judgment is unsafe because when your Lordship looks at what has transpired since then, your Lordship will see that the requirement of due process of law was not observed. I am keeping it at as general a plane as possible. These political, the constitutional, and the judicial circumstances prevailing at the time made a fair trial difficult. The apprehensions of bias expressed not only by the members of the public and journalists and historians and legal historians subsequently.
Was there
It's
any
very
basement?
general, it's very
due
general.
process
You
पे
have to
जो
be
बात हो रही है ना, you have raised first point that due process of law was not followed. So there is a question whether the charge was framed, evidence was recorded, cross-examination was done, statement under section 342 was recorded, whether the defense witnesses were allowed to be produced or not. This is the due process in the criminal trial. You want to say that these steps have not been followed by the trial court?
No, I am not saying that. What I am saying is that the requirement of due process, the pivotal requirement of due process is that the case of any person must be heard and determined in an impartial manner
Without external pressure.
and by an independent judiciary.
Was there any external pressure?
My Lord, all the materials before your Lordship seem to suggest so. And that is why,
What is that material?
my Lord, that is why the material is...
That material. I think if you read the extract of the book of Mirza Aslam Beg, it is sort of a confession or
Yes, well, my
portion
Lord,
of it.
I'm very grateful for that. I'll read out to your Lordship immediately. If your Lordship will see,
Exactly, it doesn't.
I'm reading from page 65.
This is 14 head division command.
I was promoted Major General in 78 and assigned the command of 14th Division, which was stationed at Okada. With this command, I became part of the military hierarchy and remained associated with all military matters of the army from 78 to 88. 14th Division was part of 2 Corps at Multan. General Zia ruled the country. Case of ex-Prime Minister Zulfikar Ali Bhutto was in the last stage. Supreme Court awarded death sentence to Bhutto in 79. General Zia asked the Corps commanders to assess the likely reaction of the men in uniform if Bhutto was hanged. Our Corps commander called a meeting of senior officers and asked many questions. All except me said that the reaction would be very mild and that could be controlled easily. I kept listening. When all had expressed their opinion, I sought permission to speak. I said, hanging Bhutto will be a very wrong decision. It will have very grave consequences. It will create political aberrations which will be difficult to sort out. It will be better that Bhutto should be sent to exile. And then he points out what Yasser Arafat and others were prepared to do. Corps commander got annoyed and declared the meeting closed. Later he called his Chief of Staff Brigadier Lieutenant General Hamid Gul and asked him to arrange a telephone call to COS. He did not want to see such officer in his formation.
Mr. Makhdoom Ali Khan, can this case that we are hearing be also categorized as a case presenting the Supreme Court with an opportunity to vindicate itself, as well as, I mean, martial laws are not imposed by the military as an institution. It's an individual who does it. Is it not also a good opportunity to vindicate the armed forces as well?
This would definitely...
Could it be categorized as that or not?
My Lord, I would.
Because, there must be new beginnings at some stage in our very checkered history. And we are perpetually living in the past. We're not really looking to the future on anything. So, I mean, when I find in law, not on the constitutional aspect, there are problems with the judgment, major problems with the judgment. It's not just a question of, when we go deeper into the trial and how it was conducted and how it was resurrected and Justice Shafiur Rahman's report. So, what purpose does it serve? Does it heal the wounds of a nation or does it not? Does it not enhance the reputation of the armed forces by drawing a line, placing the blame on an individual? And the same applies to this institution. Is this aspect at all to be considered, or this is in the political domain and we should not venture there at all?
My Lord, my submission is that it is not in the political domain, because that there should be confidence in the public administration of justice in accordance with the due process of law is a matter of public interest and squarely within the domain of judiciary.
But in a real case, we can always do that.
My Lord,
if a real case comes, that's the time when the judiciary is tested.
My Lord,
you should make a decision then, rather than going through this 186 process. I mean, there could be cases, there might be cases coming up. That's the time to
No, that goes without
decide.
saying. We should always do that. But the question is, it wasn't done maybe in this case. What do we do?
we can still do
Too
it.
bad. We can say too bad. It's happened. That's one approach. The other approach is be innovative. Okay, but at the same time, don't create a precedent that it is considered now a second review or everyone comes in. So you have to, if you're articulating a proposition that we can go there, then you at the same time you have to open a very narrow door which should not, be used every other day. You did it in that case, you have to do it in this case. So we have to keep that in mind. We don't want to venture into making it like a ground for a second review, then things will never end. We don't want to expand its scope. So you have to tailor-made it. I mean, it may be difficult for you, you're amicus, but can we look to you or shall we look to Mr. Raza Rabbani as counsel to do it?
My Lord, I'm sure they will do a far better job at it because they have got the particular facts
Mr.
of it.
Makhdoom, can I just speaking
Yes.
for myself about the whole matter so far? The question of law at best that you could propose, as you've done, is that we cannot look at the case itself on merits because all stands decided. We can look at the matter from outside, whether at all the process was right. Now, when we say process, the only ground that you might have could be that the judges were not independent and they were biased or they were dictated. Now, the evidence that you produce for that, I mean, it's a big ticket. You see, you're saying that the court was under pressure, was dictated. The only evidence that you come up with is that interview, which interview is not exactly in the context of this case. It is a general statement. Where is the material showing that the judges were under pressure? I mean, we'll have to please identify. That's what we were trying to write. What are those matters? To say that there was martial law, then are you proposing that, as my lord also said that earlier, that all cases decided during martial law will be thrown out of the window, or all the PCO decisions should be thrown out? What are we really doing? It's a very major policy decision that we need to take. Suppose we do open it up only in case of grave injustice that has taken place, which to me translates as the judge was not independent. The only evidence is an interview, which is not in this case. So what are we saying?
Before you address this, can I just tag on a little bit of to that? As far as the general proposition that all murder trials during martial law regimes are therefore held to be void, or whatever word you want to use it, voidable, I would say that probably, or more certainly, in those cases, the commander-in-chief had no personal interest in the matter. So, I mean, we should just maybe keep those two things together. I mean, here it is, okay, if I don't succeed, what about Article 6? Okay, so it's not like everybody, all the other judgments, I mean, Allah Ditta is murdered, whoever else in Mandi Bahauddin would not really matter. What is the interest of the martial administrator to secure one type of conviction or not a conviction? But here is the prosecutor itself fair, the prosecution, who is the prosecution taking instructions from the person who is directly interested in a particular result. Now this probably, if we narrow it down like this, we may not need to say that all trials during 10-year period are all vitiated. Would that not be possible?
My Lord, the submission in this case precisely is that your Lordship will have to look at it with this very narrow window. When your Lordship looks at the circumstances of the case, of course there's a general situation, but that General Zia at that time was interested in this case coming out a particular way is now a fact which has been part of a number of history books. That the trial was moved from the Sessions Court, the bail was cancelled, the High Court constituted a 5-member bench to hear it, that the animus of the Chief Justice of the High Court with the accused...
Who cancelled the bail?
Justice Maulvi Mushtaq Hussain.
And it was given by Justice Samdani?
Justice Samdani. So when you connect all these facts, it's a one-off. You will not find...
So, when you are giving these general propositions, if you can restrict them, like, I think, my lord, like due process of law, I mean, these, if we broaden it up, it may apply to all other cases.
No. I'm saying these facts demonstrate to your Lordships that there is a reasonable apprehension that the due process of law was not followed in this case. My Lord, in the cases where so-called bias or duty to act fairly is alleged, it is impossible for any litigant at all, to prove bias. Because
Mr. Makhdoom, one of the amicus who's not here in person, a professor from Oxford, Professor Yasir Qureshi, sent a note and I'm just reading this paragraph, it's very important. It says, in many parts of the world, states are finding ways to remedy past injustices,
My Lord.
including in periods of military dictatorship and other forms of unconstitutional rule. This is being done through establishing truth commissions, and he refers to the Brazil National Truth Commission, where people could appear before. granting executive and legislative pardons. So there are other avenues also to rectify this issue.
Yes, my lord, what has happened?
The question is, this is the avenue chosen.
Yes.
Whether this is the avenue available.
Maybe it was not the best avenue. We don't know. Well, we still have to answer the questions.
This may be an opportunity to close door and stop intervention, if any, from outside.
We'll take a short break and we come back.
My lord.
How long would you take?
My lord, I'll try to wrap it up in 30 to 40 minutes maximum, not more.
So at least we should conclude with your submissions. What is it called? Submissions or advice? Oh,
Submissions, my lord.
Okay. So we'll take a short break and we'll. What time should we reconvene?
2.
Like half an hour break. Is that all right?
Yes, my lord, that's fine.
Okay.